Okay, good morning. We're here in the city of Kenmore. We're calling to order an appeal hearing. It's March 4th, 2016. Mr. Owen Benson has appealed a notice of violation that the city issued in February. And the purpose of this hearing is to allow the city to put forward its evidence, as it has the burden to show by preponderance of evidence that a violation may have occurred, and then to allow Mr. Benson to respond to the city's presentation of evidence. This involves property located at 16424 76th Avenue Northeast in Kenmore. And I'm aware that other citizens, Mr. King and Mr. Thompson is here. They've also expressed an interest in this appeal, and I'll speak to that in a moment. I'm Ted Hunter of Sound Law Center, who the mayor and council have chosen to hear and decide certain land use matters, including those involving alleged violations. So there's been a lot of activity on this matter prior to the hearing today. I want to summarize some of that. I note that I think it's undisputed that there was a notice of violation issued by the city on February 4th. It named three people, Mr. Benson, Mr. Paul King, and Mr. David Thompson, as persons responsible for the violations. Mr. Benson filed the appeal form, and he checked the box requesting a contested hearing. That came in on February 8th. I'm also aware of the notice of appearance that Mr. King and Mr. Thompson filed, various dates on that, January 5th, February 9th. It was received by the city on February 12th after I issued a pre-hearing order. Also, I'm aware of the amended appearance. It was filed just 2 days ago. So a date for the contested hearing between the city and Mr. Benson was set for the date today. On that pre-hearing order in February 11th, I established dates for the filing of witnesses and documents. I received those from the city, and the contested hearing now between Mr. Benson and the city is what I'm now considering. Mr. King and Mr. Thompson did inquire about a separate hearing for each of them, or a dismissal, in what I think is fair to say is a memoranda. And Mr. Thompson's here this morning, and we clarified that wasn't really a motion, but it was a memo asking, what is this about today? And the city responded to that memorandum, and I've concluded that there's no separate contested hearing at this time for Mr. King or Mr. Thompson. It involves Mr. Owen Benson. And whether there's further action by the city with reference to Mr. King and Mr. Thompson is between the city and those two individuals. That's not a matter before me today. I did receive two motions from Mr. Benson on February 26th. One was a motion for a continuance, and the second was a motion for a change of venue. I considered those motions, and I did issue a denial of both of those, which is why we're here today. Also, at the end of the day, March 2nd, 2 days ago, I received a motion to dismiss from Mr. Benson, Mr. King, and Mr. Thompson. That motion alleges lack of jurisdiction to hear any matter involving them because they're alleging improper notice. And you filed a detailed brief with that motion. So I think today, as we discussed just prior to convening the hearing, I'm going to first take up that motion to dismiss, or entertain the motion that was submitted by Mr. Benson, Mr. King, and Mr. Thompson. Now, I think with reference to Mr. Thompson and Mr. King, a motion to dismiss is premature, really, because there hasn't been any hearing set for them. So we're going to focus on the motion with reference to Mr. Benson. The city really has not been given an opportunity to respond to the motion, so I'm going to check with the city first to see if they'd like to respond at this time, and then if they do, I'm going to rule on that motion, and then we'll determine whether we continue with the hearing or whether we call it a day. So I'll turn to the city first and ask if you're prepared to respond to that motion to dismiss with reference to Mr. Benson.
We are.
Okay, and this is Mr. Bill Linton.
Yeah, Bill Linton, representing the city as a city attorney. Thank you, Mr. Hearing Examiner. We just received this motion, so first of all, it's late in relation to these proceedings, but That aside, I think that's more than ample reason to deny it. But the second thing is that jurisdiction under the Kenmore City Code, Municipal Code, I should say, occurs when a notice of violation is served in accord with the code. Service includes posting, which was done, and also mail. Both of those things occurred. Also, I believe that any question about jurisdiction has been waived by virtue of the appearance of Mr. Benson, both in a formal notice of appearance that was filed, even though there was some reservation of affirmative defenses. I believe that under the municipal code, once someone requests an appeal, files the appeal form, and pays the required fee, that they are committing to and agreeing to the jurisdiction of the hearing examiner to consider the matter.
Let me ask you about the notice.
Yeah.
You mentioned posting and mailing.
Yeah.
Are both types of notice required for there to be sufficient notice?
No, either one works.
And I'm going to give you time to respond. First, I want to hear the city, and then we'll give Mr. Benson time to respond. So under your ordinances, the way you're in reading them as a city attorney is that either posting or mailing is sufficient notice of the notice of violation and the opportunity to appeal. Did you want to take a minute to find that in the ordinance itself?
Yeah. I would just direct the attention of the hearing examiner to Exhibit C3. That shows on page 9, it's labeled page 9. It's a photograph that shows the posting that was done. 9, 10, and 11 show the posting of the NOV.
Well, okay, and I'm not asking about that. I'm asking whether you need both types of notice or whether one is sufficient for jurisdiction.
I believe that
would relate to what your ordinance.
I believe the wording of the ordinance is disjunctive. I think either one works.
Well, let's find that. That's what's key here.
I have the code right here.
Yeah, and is that section 060? Is that what you'd look at, Mr. Linton?
Yes, that's it. I don't have it right in front of me here. Let me grab it.
That is an issue that is important for me to determine with reference to Mr. Benson, because there does need to be, as part of procedural due process, sufficient notice of the opportunity to appeal. I understand your argument is, well, whether or not that was sufficient, he did file an appeal.
Well,
So
no,
that sort of waives
but
that.
we did mail and we did post. So I guess I'm not seeing what but
It's easy enough to read. Shall I read it for you?
yeah, please, yeah.
Okay. What I'm looking at is the section dealing with notice of violation. And the notice of violation section is section 080, and subsection C is entitled Service of Notice of Violation. And this ordinance says that service of notice of violation shall be accomplished as prescribed by section 060. And if we go to 060, that deals with the proof of service, and it's entitled Methods of Service. And I think this is what was brought up in the motion to dismiss is the subsection A, which was cited by Mr. Benson in the motion. And as I recall the motion, it alleged that, first of all, the code reads under subsection A, code enforcement officer shall use due diligence in attempting to locate a mailing address. And I think that's one of the allegations, is that due diligence was not used to find mailing addresses. And then the second allegation is that because notice wasn't sufficient, that the hearing should not go forward. So it is curious, Mr. Linton, that the disjunctive is used in other sections, but for notice of violation, it relates back to this methods of service, where it just defines what those methods are.
I think perhaps I was thinking about the publication versus mailing and personal service.
Mm-hmm.
But in this case, in any case, we mailed and we posted to the property.
Okay, and do you have a proof of service? Is that one of the
Well,
exhibits?
I have the testimony of the.
But I don't have that in front of me yet, do I?
No, not right now.
So there's no proof of service, like an affidavit or a certificate of service, as one of your exhibits?
No.
Okay, because I do note that section 060 does state that proof of service shall be made by written affidavit or declaration under penalty of perjury, declaring time and date of service, the manner in which the service was made, and if service is made solely by posting, facts showing that due diligence was used in attempting to locate a mailing address for the person at whom the notice of violation is directed. Do you see that subsection C?
Subsection C.
Yes, of 060. And that's what you're prepared to present today, is that correct?
Well, yeah. I would point out that C does use the disjunctive, the manner by which service is made, and if service is made solely by posting or publication. So that appears to provide
that implies that posting alone would be sufficient.
Right.
Okay. Yeah, I'm referencing that because I think that the motion, although I agree with you, is a bit late. It does go to a primary due process concern, and that is sufficient notice. And I also can agree with you that it seems to be waived once you file an appeal. However, because we have an interest in this beyond this hearing today, I think it would be appropriate for you to present a witness in response to the motion, because that I don't have that in front of me now.
Right, right, and I'm prepared to do that.
Okay. Perhaps we should do that at this time.
Okay. So we'll call Mike Thomas, who's our.
Okay. Mr. Thomas, if you please raise your right hand. And do you swear to tell truth in the testimony you give today?
Yes.
Okay, and I think your attorney has some questions for you then.
Mr. Thomas, could you explain how the notice of violation was served? Was it posted? Was it mailed? How was it done?
It was posted and sent in the mail and also posted at the residence.
Well, and part of the question is the declaration. If we look closely at that, Mr. Linton, declaring the time and date, the manner by which, if it was made by posting, showing that due diligence was used to attempt to locate a mailing address.
Right.
And I don't have that in front of me,
Right.
so.
And I was just kind of getting to that.
Okay.
If you could take a look at.
The notice of violations back here itself.
If you could take a look at C8.
C8, 9, 10, and 11.
Could you identify Exhibit C8 for us? What is it?
Exhibit C8 is a notice of violation. If you look at page 9, 10, and 11, it shows where I posted it at the residence. If you look on page 11, you can see where I've posted other stuff at the residence that's been removed. Obviously, it's been seen by the people that live there.
Had you previously posted notices in that area?
Yes, I have, and I've received emails and phone calls, follow-up afterwards.
Okay. Had you ever heard from Mr. Benson?
Yes.
Okay.
I heard from him on the phone after I posted the notice of violation, and I also saw him out there when I was posting the notice of violation.
Where is it on C8, the time and date of posting?
Photo number 11, or page 11 on C8, on the bottom right corner says 2/4/16/1434. So that would have been 2:34 in the afternoon of the day of February 4th this year.
And you're talking about the digital camera date? Is that a date that you established, that you
Yes.
input into the camera?
Yep, I've said that, and I've used it on all my pictures that I take everywhere, so it's an accurate record of when they were taken.
And you took that photo at the time that you posted it?
Yes, sir.
Okay.
You can see there's 3 photos there. They were all taken within the same minute at 2:34 p.m.
All right. You have further questions, Mr. Linton?
Well, there's some question as to whether this posting site is near the entrance. There's in the motion there was a mention that it was some 40 feet from the entrance. Entrance, to my knowledge, is not defined under the ordinance. Where do you enter the property? If you're going to walk up to the door, where do you enter it?
The front door is to the left of the garage,
Okay.
or you could enter through the garage.
Do you walk up the driveway if you're going to walk toward the front door?
Yes, you definitely do, and it's contrasting colors to the house and very noticeable.
Okay. I believe that shows that we've adequately posted and that we mailed it to the address. I would also point out.
Well, wait a minute. Because this affects other aspects, I need a little bit more detail. And posting a conspicuous place on the property. And is this something you could see if you, Mr. Thomas, if you walked onto the property?
Very visibly. There's an extremely long driveway to the house, and you pull on the property and you turn up a hill on your way up to the house. And when you walk up to the house, you walk down the pavement part of the driveway, and you see it very clearly right in front of the house. And like I said, those other correction notices, I've received phone calls and emails afterwards stating that they were received and inquiring about questions about what I was.
Oh, okay. And what do you consider the entryway to the property? Is it the driveway?
Sorry, go ahead.
Would it be the driveway?
Yes. You walk up the driveway to go enter the house.
And so did you post one at the driveway itself? Doesn't the pavement end and then there's a driveway that begins?
The pavement ends and there's a gravel driveway that goes to the entrance of the property, but there's nothing to post anything to right there. It's just there's just grass and.
Okay,
dirt.
so you posted this on a structure then?
I posted this at the actual house,
Okay,
where it would be seen by anybody coming home or living at the residence.
all right. I'm looking at this with reference to Section 060 of the ordinance, so thank you. One other question related to the proof of service is your ordinance requires that you engaged in due diligence to locate a mailing address for the person at whom notice of violation is directed.
Yeah, and we can show that. Do you know what address the NOV was mailed to? You want to take a look?
16520 72nd Avenue Northeast.
And if you take a look at Exhibit C1, could you tell me if it was mailed to that same address that shows Mr. Owen Benson?
Which exhibit are we looking at?
C1, the property profile from King County.
Mm-hmm.
And that shows 16424. So from our records, there's multiple addresses for this house. That's why I posted everything there as well, because there's not really a set in stone address. I've seen multiple ones for the house, and it's hard to make certain that anything will get mailed there correctly.
So, did you receive any return mail?
I have received return mail from this house before, as I've sent it to multiple addresses before in attempts of making it there. But that's why I posted it, because I was never certain if anything ever got received in the mail there. But we did send it out in the mail also.
Okay, thank you. Anything further at this time? No? All right. So, Mr. Benson, we turn to you filing the motion to dismiss your appeal today, and you've heard the city's response as to how they effectuated service or notice. Did you want to respond to the city?
I just would like to say that I'm happy that they have the correct address now.
Okay. Yeah. So I'm going to rule on the motion, and I spent a little extra time on it because I'm aware that Mr. Thompson and Mr. King are also concerned about this issue, so we basically tried to build the record as to what may have happened for your benefit. With reference to Mr. Benson, I'm going to find that since he did file that appeal and sign the appeal, that the appeal is before me today, and I will not dismiss it with reference to Mr. Benson. So we'll proceed to the appeal hearing then at this time. And to do that, we turn back to the city, and it's the city's opportunity now under your ordinances to attempt to show me by a preponderance of evidence that violations have occurred or are occurring on this property.
Just before we get to that,
Mr. Linton.
could we talk a little bit about what we discussed previously off the record about Mr. Thompson and Mr. King asking for that separate hearing and that whole issue? I know the hearing examiner didn't consider that to be a motion, but we were going to put something on the record as to how that's being dealt with or not dealt with here today. And it's the city's position that there is no appeal currently pending by Mr. King or Mr. Thompson, that Mr. Thompson's appearance here today is solely as a witness, that to my knowledge Mr. Thompson is not an attorney, that he's not representing Mr. Benson, that Mr. Benson does not have an attorney here today. As we previously stated, if and when Mr. King appears, he is no longer an attorney and cannot represent. And the distinction there is more than just a minor one, in that the only person that would be entitled to cross-examine any of the city's witnesses would be Mr. Benson, I believe, as a party. I don't believe Mr. Thompson, as a witness, is entitled to ask our witnesses any cross-examination questions.
Well, you're kind of raising a pre-objection. We haven't had that happen. He hasn't asked questions of your witness. But I appreciate that you're trying to smooth things out in advance of that occurring. This is a hearing examiner forum. It's not a court of law. There is the concern about an attorney or someone acting as an attorney without an appropriate bar license. But we are fairly flexible typically in these hearings, and have been in the city of Kenmore, and allowing citizens to participate. So the primary interest is getting the information out. So I don't know if that'll happen. If Mr. Thompson, were you planning to ask questions of a city witness? Are you here representing Mr. Benson?
No, I'm here to help him.
Yeah.
And, you know, I'll give a help find it if that's for him.
Yeah, okay. And I think that's fine, and he's here in the capacity of assisting, who I assume is a friend of yours or someone that you've known for some time, and I want to allow you to assist him. The point the city attorney is making is we don't want to look to you as if you're acting as an attorney, because that could get you into trouble.
Legal, ain't it?
Well, it's a matter of the Bar Association. We don't want a complaint to be made to the Bar Association. So, okay, I think that's a common understanding.
I just thought I'd bring it
Good.
up. I didn't mean to.
We'll proceed in that way. It seems like Mr. Thompson's well aware of any risk that he might step into along those lines. So good. You have one witness then today on behalf of the city?
At this point, we might have an additional rebuttal witness possibly,
Okay.
Depending on what Mr. Benson decides to bring forth. And so just to be clear, this is only Mr. Benson's appeal. We're not dealing with Mr. Thompson or Mr. King.
That's right.
Okay.
Thank you for that clarity. At this time, we have nothing before me with reference to King or Thompson.
Okay, thank you. So I believe the hearing examiner and Mr. Benson have a copy of our exhibits, and we'll just start with Exhibit C1. Could you tell me what Exhibit C1 is, Mr. Thomas? Before we get into that, some preliminaries. Mr. Thomas, what's your position with the city?
Code enforcement officer and building inspector.
Okay. And what's your general experience in...
You know what? I'm going to, before we continue, because I want everyone to be able to see the witness, and there's kind of a block here, would you please present your testimony over here at this witness chair?
Sorry.
You know, we don't see each other a lot in this forum.
No,
in fact, I don't know, have you been in this forum before? I know we've had a number of
Actually,
interactions, but
and we'll get to this, but I represented the city on the previous appeal back in 2013.
With this property?
With this property and with
Okay.
you as the hearing examiner.
okay, I
Yeah.
knew there was familiarity.
There's
and
something,
thank you.
there, yeah.
Yeah, which I have a question about that because that involved a different party than Mr. Benson, correct?
It involved Mr. King and Mr. Daub.
Yeah.
Yes.
So I know you
Yeah.
submitted that as an exhibit, and it's not my rule to raise any objections to it, but I wasn't sure why. But if we get there, we
Yeah,
can-
we'll get to that.
Okay.
Yeah.
All right. Right now, though, we're prepared to listen to Mr. Thomas as a witness here on behalf of the city and responding to any questions you have for him. And it's okay, too, to move to narrative testimony if you find that suitable for your witness.
I think we'll definitely get to that and
Okay.
try to move through the exhibits as quickly as possible. Mr. Thomas, again, could you just give us a brief description of your work experience, professional experience, as far as construction and familiarity with construction practice, that sort of thing?
I've been in the construction industry for a decade now. I have a degree in construction management. I'm a registered residential building inspector with the International Code Council for building.
Okay. And where did you get your degree from?
Renton Technical College.
Okay. And are you familiar with, as a registered building official, are you familiar with spotting unsafe conditions and that sort of thing?
Yes.
If you could turn to Exhibit C1.
And did you say you're the building official and also code compliance?
Building inspector.
Building inspector.
Yep, and code compliance officer, yes.
Thank you.
And could you describe what Exhibit C1 is?
C1 is the King County Department of Assessment for the property we are speaking of today.
And does it have a legal description?
Yes.
Okay. And is this the property that we're talking about in this instance?
Yes.
And if you could take a look at Exhibit C2. And if you could just tell us, this Exhibit C2 appears to consist of 16 photographs, and the date of September 29, 2015 is in the bottom right-hand corner of each photograph. Is that right?
Yes.
Okay. And so I believe you were asked this before, but just, for the sake of clarity and identification, is that the date that these were taken?
Yes.
And how can you be sure of that?
I set the camera for the time and date stamp, and I check it every time I use it to make sure it hasn't, it's accurate.
Okay. So on September 29, 2015, when you took these photographs, what were you looking for?
Any code violations were responding to the neighborhood's concern about the property. So it was our first inspection out there to see what issues may arise from
Okay.
violations of the municipal code.
Had you received complaints from neighbors?
Yes.
Okay, what types of complaints?
Written complaints, phone calls, and meetings.
And what did those, what was the general nature of those complaints?
I'm concerned about safety for the property, safety of the barn, safety of the pool, the deck, concerned about junk vehicles, various code violations, including storage of materials on site, not for that site.
When you say complaints, is that from a number of individuals or one individual?
One.
One individual. An adjacent property owner, do you know?
Yes.
And so page number 1, what does that show? And
Page number 1 shows vehicles stored. If you're not familiar with the property, you pull in at the bottom of the property, which would be the north side, and there's a lower parking area, which is what this shows right here. At the time, they were using, it appears that they were using their property commercially, rented out for storage of vehicles for a company.
is that allowed by Kenmore ordinance?
No.
Is what allowed?
Storage of commercial vehicles.
Storage of commercial vehicle, is that in the notice of violation before us today?
No, it's in the correction notice, the following one from
Well,
this,
I'm-
but
okay.
it got dropped before the notice of violation because this
All
issue
right.
was resolved before that.
So we're going to focus on the notice of violation.
And certainly, it sort of feeds into the question of how many vehicles are on the property versus the storage of commercial vehicles. It's more in relation to the number of vehicles and the fact that we've had an ongoing problem.
I see. I'm a little concerned about going through each photo. Are there photos that I can be directed to that relate to the alleged violations?
Certainly.
And maybe Mr. Thomas can reference which ones are the ones you're relying on to show that there were, in your opinion, violations of the code.
Yeah, so if you go through, you basically have to count the number of vehicles in there, but the numbers of vehicles that I counted was 11 vehicles on site at this time, which is over the legal amount. They're allowed to have 8 vehicles on site because it's an over 12,500 square foot lot. That's per KMC 1840-110.
And if you turn to page, in response to the hearing examiner's point there, if you turn to page 4 of Exhibit C2, that appears to show a derelict vehicle. See the sedan in the background there? Is that a derelict vehicle?
Yeah, that'd be classified as a junk vehicle.
Yeah. And is that one of the citations that we have in the NOV?
Yes.
Okay. I believe page 5 also shows that same thing.
Correct.
The same vehicle?
Same vehicle. And what constitutes a junk vehicle? under the ordinance?
A junk vehicle has to meet 3 of the following requirements. 3 years or older is one requirement. Extensively damaged but not limited to broken windows, windshield, missing wheels, tires, motor, transmission is another requirement. C is an apparently inoperable. D, without valid current license plates or tabs. Or E, has a fair market value that is equivalent to scrap value.
And did you get a closer look at that, what appears to be a sedan that?
Yes,
Partially.
I would say it is older than 3 years. It's not appear to be operable and did not have a valid current license plates or tabs.
Okay. Then if you take a look at page 7, which appears to show a travel trailer, does that have anything to do with our current claims?
Yeah, that travel trailer is classified as a vehicle and is still on site, so it would be counted under the NOV count.
Okay. Then, if you take a look at the next page, 8, what's that a picture of?
That's a picture of the barn. It is in the NOV as an unsafe structure, as defined under the Uniform Act for the Abatement of Dangerous Buildings. We weren't able to get into the barn on this date. We looked at inside the barn on a separate date to photograph the unsubstantial structure and the unsafe framing on that barn, as well as other violations.
Okay. Now, there's somebody standing in the picture in a red shirt. Who's that?
He was the person that was on site that day. I didn't catch his name because he was kind of insignificant in the case.
Okay, and then take a look at page 11. You see that that photo. Can you describe any violations or how that's relevant to our claims here today?
That'd be the house at the top of the driveway. We dropped the claim of outdoor storage of debris. That was on this correction notice, but we dropped it later because it all was cleaned up. Just the vehicle count would be involved in that claim.
Okay. So those vehicles contribute to the vehicle count?
Yes.
Next, page 12. Looks like there's a large van there to the right. Does that have to do with your vehicle count also? Or?
Yes.
Okay.
Can you help me understand, you had, a recreational vehicle and now this van. Are they defined in your code as vehicles?
Yeah. They're all, anything that you can drive is defined as a vehicle.
Anything you can drive?
The I don't have the definition off the top of my head, but it'd be in the code book.
You need to speak a little bit more slowly so that we can, this is being recorded, and if there's a transcript necessary, someone is going to be listening and trying to type it out.
Okay.
So did you tell me you have a definition of vehicle in your code?
I believe so.
It's important for me to know that because you're testifying that your count of 11 vehicles included at least one, I don't know, do you call that a camper van? And now this, which looks like more like a service van. And each of those that you referenced, they're not operable on their own, are they? You couldn't get into either one of these and drive it as it is.
This one at the top that's on page 12 is a big U-Haul box truck, so that is a drivable vehicle.
Yeah, you don't see the cab, Mr. Hearing Examiner.
I see.
Yeah.
Okay, a U-Haul van.
And you'll see that one again in subsequent pictures
Okay.
also.
Well, the
Well, and we'll
concern was
find-
first raised with reference to an earlier photo on page 7, which I guess I'd describe that as a camper van that goes on
The travel trailer.
or a fifth wheeler or something
Yeah,
like that.
yeah.
But it's clearly not something you would be able to drive without a vehicle being attached. And I'm sorry, Mr. Linton, I don't want to take you off your course, and you can object to me if I'm going in the wrong direction. But as we're going through these in the city's offering of proof of alleged violations, these questions come up in my mind. I'm going to need to do findings. And how is that?
More than welcome to
Okay.
interject wherever.
Great.
Absolutely.
Thank
We want to answer your questions.
Okay.
Yeah.
So that is a
So-
question I have.
And
is how
we're
is that
looking up the definition right now.
Okay.
Might take us just a minute here.
Because I noted in the notice of violation, which really governs the scope of this appeal, that's what I'm interested in, is the alleged violation is under 18.40.110, and it just notes that the total number of vehicles parked or stored on a single-family lot, excluding recreational vehicles and trailers, shall not exceed 6. That's why I raised the question. Do you see that in your exhibit? Exhibit C8, Mr. Linton.
Right.
So I was curious why your witness was saying, yes, I count recreational vehicles, when the alleged violation specifically excludes that.
I see your point.
So there are 11 vehicles, not including, we can count them real quick if you would like to see how many are there in the.
So we don't count, I take it we don't count the recreational vehicle?
Correct.
The trailer?
Yeah, it would only
Okay.
be something that you can drive,
Okay, all right.
which is
And-
why in the notice of violation, you can see that
What's the citation on that, Mr. Thomas? The citation on the vehicle, the definition of vehicle, do you have that? What
Oh, the code
The code
section.
section, yeah.
Non-attorneys think of citations. as
18, yeah,
something different.
18, as I recall,
18
it's in 18,
1840, chapter 1840.
Yeah.
184110 would be where it states what.
It doesn't define vehicle, it just excludes recreational vehicles and trailers.
Mhm.
So we'll count this as clarification of testimony.
sure.
And your witness's statement, to make sure I understood this correct, is that there were 11 not including recreational vehicles?
Yes.
And the limit is, in this code section, 8?
Eight for a lot over 12,000 square feet, yeah.
All right, and I'll have to determine whether he's am I to rely on his statement that I counted 11, or are we going to rely on the photos?
Well, the photos, I believe, illustrate the vehicles that he counted. I don't know if it shows all 11 vehicles, but your testimony, Mr. Thomas, is that excluding trailers and recreational vehicles, you saw 11 vehicles on the property in September when we're talking here on C2.
Yes.
Okay. So I think you can count on both of them, Mr. Hearing Examiner.
Mm-hmm. And did you see those on numerous occasions?
Yes. Yeah, every time I was there, there was more than 8 vehicles out there, and there's been different vehicles, some there and some gone, but there's always been more than 8.
So if somebody's visiting the property, do you know how to count or not to count that one?
I couldn't tell you who's parking there overnight, who left it there for a week, who is leaving a car there temporarily, or it's hard to tell what the purpose of it.
So in your role as code compliance officer, if it's parked there, that's all that matters, not whether it's a visitor or...
Yeah,
there
I
for
can't
2
sit
hours.
outside someone's house all day and see when they come or when they go, or,
Is that a violation of the code if there's more than 8 parked on a site?
yes.
Okay. Someone has a gathering, a family gathering, or a party, that if they have more than 8, that could also violate the code. Is that correct?
Well, the code says the total number of vehicles parked or stored outside. So I guess it's up for interpretation. Someone has a party and they have a bunch of people over, and they say they have 10 cars parked at their house. I guess that would ensue a violation of that. I don't think that's something that we would actively search out and enforce, because this is a complaint-driven system that we operate. So
Okay, so you have some discretion as
Yeah.
to whether to issue a notice of violation?
yeah, we wouldn't issue a correction notice for anybody that has a gathering at their
Okay,
their home.
thank you. All right.
Great, thank you. Then if you take a look at page 14 of Exhibit C2, see stop work notice, what's that pertain to?
When we were on site that day on 9/29, we could hear hammers swinging and work going on the deck. I inquired what was happening, and I was told that there was work going on the deck. At this point in time, we issued a stop work order as there was no permit that was issued for the repair work of the deck.
Okay. And you checked whether there was a permit issued for the deck?
And there wasn't one. So on a later date, they received an over-the-counter permit for deck building with the generic plan. There's no plan submitted for it.
Okay, so on September, and this says September 30th site visit, excuse me, the photographs September 29th, and I believe it looks like, what's the date? I can't tell from the stop work notice there
The
what the date
date's
is.
9/29 is what's on the stop work order. I think that where it says September 30th, that was the day I uploaded them on the computer, which was the following day.
Okay, all right. But the day you were there was September 29th. The stop work order was posted on September 29th.
Yes.
And when you say they obtained an over-the-counter permit, what does that consist of? And
You
could you
can-
explain the process and what that is?
Yeah, so when you apply for a permit, typically you submit plans for it that get reviewed by the plans examiner and they get approved, or corrections are issued for that. An over-the-counter permit, you don't submit plans for. They're issued over the counter. You come and apply for it, and you pay the fees, and you get your permit issued that day.
So does that require submittal of engineering or anything like that?
No, it doesn't. It's based off of the prescriptive requirements of the International Residential Code.
And what are the prescriptive requirements of the International Residential Code?
There's specific joist spans and beam spans and ledger attachments that are straight out of the code book. They're not engineered. They're based off of what the code requires. They're minimum requirements.
Okay. Are you familiar with those?
I am familiar with them. I don't have any of them off the top of my head, but I am familiar with them. I've done plenty of inspections based off of them.
Okay. And in later exhibits and in the NOV, the deck is one of the sources of our citations, correct?
Yes.
Okay. And in issuing the correction notices and eventually the notice of violation, did you take a look at those codes to determine whether the deck met those codes?
It does not meet those codes.
Okay. And so you evaluated that
Yes.
and came to that conclusion? Okay. And at September 29th, you reviewed and whether there was a permit, and no permit was in existence as of September 29th, 2015, right?
Yes.
Okay. Then on page 16 of Exhibit C2, could you tell me what that consists of? What's the relevance of that photograph?
Outdoor storage of debris, which was a violation of our KMC, which I cited on the correction notice that is under C3. It's not on the notice of violation because it was resolved before we issued the notice of violation.
Okay, we're going to stick
So,
to the
yeah.
notice of violation.
Okay. And I apologize for that. We've got some things that were
You have a
cited
lot of
initially.
photos into evidence. Yes, I take note of that. A lot of photos. and we're going to try to focus on those that you're offering to prove your case. A number of photos, I take it, were attached to the correction notice. Is that what happened?
That's correct. Yeah.
Okay. So did you want to get into detail on the correction notices?
Just insofar as they relate to the NOV claims. What we're trying to show is that there were correction notices given for these conditions repeatedly up until the NOV was, the notice of violation was issued, and that none of these conditions have been remedied as of today.
Okay. And why would that matter to me, that pattern of correction notices? Why does that make a difference?
Because we're asking for $500 a day penalties for failure to correct.
Right. And that's based on your notice of violation, the allegations in there, isn't that right?
Well, yeah, but the date that the violation started and it was failed to correct.
I see. Okay.
It determines the number of days that we.
Okay. Is that where we're going next? Because you do have exhibits with dates on them as far as correction notices. But as we've already heard from your witness, some of the allegations in the notice of correction have been corrected or no longer alleged in the notice of violation. I don't think I can go back to those. I have to look at the notice of violation as far as what the city might request. I can't take a correction notice indication of violation and say, well, I'm going to go back to that date. Right?
As far as computing the penalties we're
Correct.
asking for?
Yeah.
Well, our reading is that once a correction notice is issued, the failure to correct creates a liability of $500 a day for failure to correct. And so under the correction notice, their failure to correct for instance, the correction notice dated Exhibit C3 was issued November 4th, 2015. The respondents were directed to correct says, please correct the violation described above on or before November 25th, 2015. If violations are not corrected, the city may issue a notice of violation. The date of their failure to correct, as directed, subjects them to penalties dating from that date that they failed to correct. Otherwise,
is there authority?
Otherwise, if we, yeah, I mean, we can take a look at the ordinance.
Yeah.
Sure.
And the reason we're doing this, looking at this now, is that I understand the next set of questions would be regarding those correction notices, and the issue is whether we would take the time to go through correction notices or notice of correction when it's the notice of violation that defines the scope of this hearing.
I'm looking at.
And what I look at is Section 160. For each alleged violation of the city code, I must make a determination of whether the violation has been found committed or not committed.
Yeah, and the question that 160 doesn't answer is when. And to find that out is, one is 030. Each day or portion thereof in which the violation continues constitutes a separate offense for which separate notice of violation may be issued. Code enforcement officer may, pursuant to this, issue a notice of violation. So the violation doesn't go from, it goes from the date of the violation, not the date of the NOV. Because the violation occurs as of November 25th when they fail to correct. Otherwise, and that makes practical sense, Mr. Hearing Examiner, because otherwise we end up having to have another hearing down the road to determine the amount of a penalty.
Mm-hmm. I follow you, and there is a definition of violation in the code. I'm okay with that, but we've already gone kind of down a different road of looking at violations that may have been corrected. And those we don't want to look at those.
No, we're not asking for, we're not asking for assessment
We've done that twice so far where the witness has testified about violations that have since been corrected. And if that's why we're going into these correction notices, that would be time not well spent. But if you're looking at for when the alleged violation may have first occurred, they can be brought in for that reason.
That's why we're doing that.
Okay.
Yeah, exactly.
That can be done fairly quickly.
Yeah. So, and maybe what we should do in that, in relation to that is we'll just jump to C8. If you could. Let's talk about the violations we're talking about today. And perhaps we should have put C8 up in the front because that's
That
what we're
sets
really
the tone,
talking about.
sets the scope, yes.
Yeah,
okay.
right. Like starting a novel with a flashback. Sorry about
Right.
that.
It's all right.
Right. So, do you recognize Exhibit C8?
Yes.
And could you go through the violations and describe what we're talking about here?
Yes.
Okay.
Violation 1, KMC 1840-110, off-street parking. I think we've talked about this since the beginning, where they can only have 8 vehicles on a lot bigger than 12,500 square feet. And once again, on January 8th, there were 10 cars and a tractor on the lot. The reason I separated the tractor is to verify what was considered a vehicle and what was not, as it's a drivable vehicle.
Does it matter if there's 9, 10, 11, or 50? It's at the same
A violation is a violation.
Okay.
Yes. Just wanted to be real clear and everything. Violation number 2, the junk vehicles. I think we've gone over this, what the qualifications for a junk vehicle are. On January 8th, 2016, the orange dump truck on the southeast side of the lot and the brown car at the lower parking area of the lot are both junk vehicles. They were not completely enclosed in a building in a lawful manner. Violation number 3.
Excuse me. What vehicles are you counting as junk vehicles?
The lower area where there's that car, the brown car that we talked about, and there's also the orange dump truck. So I can show you the picture of that on C2.
Is it page 11?
It doesn't look like there's a very good picture of it. If you look on page 40 of C4, you can see it in the background of that picture. I'm trying to find another one that shows a better picture of it.
Page 40 of
Yeah.
C4?
Yes.
This is what you observed on site?
Yeah, it's been there the whole time.
What's the date on that photo?
On 40 of C4, it's 12/1/2015. Oh, here we go. Page 13 of C4 is a better picture of it.
Was that 15? Page,
13 of C4.
okay.
And that vehicle's been there the whole time, like I just said.
I'm sorry, what did you say?
That vehicle's been on site the whole time.
The whole time, meaning what? From
Meaning since my first visit,
First visit
December
in September 29th, 2015.
yes.
Oh, not December 1, but September 15th?
September 29th, I believe.
Okay, why is the date on the photo is December 1?
That's when this photo was taken, but our first site visit in regards to junk vehicles was September 29th,
2015.
2015. Yeah.
Okay.
And the first correction notice where it was cited as a violation is Exhibit C3. Junk vehicles, page 2 of the correction notice dated November 4th, 2015.
Okay, thank you.
Violation number 3 on the notice of violation is a violation of Section 302 of the Uniform Code for the Abatement of Dangerous Buildings. And here we're talking about the deck. On December 16th, 2015, the deck on the back of the residence is a dangerous building pursuant to the requirements of subsection 3, 5, 9, and 13 of 302 of the Uniform Code for the Abatement of Dangerous Buildings. The city has issued a permit for the deck repairs. As of January 8th, no work has been completed on the deck per the approved plans. So we issued a permit for this deck to repair it per the prescriptive requirements of the International Residential Code. The permit was issued. There was never any inspections on the deck for any repairs.
And did you observe the deck on your various site visits? And were any of the repairs of the deficiencies made?
The deck was observed on December 1st, 2015. That was the date where I was able to look in the barn and look around the deck. You can see there's quite a few pictures of the barn and the deck on this visit.
And what exhibit are you looking at there, Mr. Thomas?
Sorry. C4.
C4.
Yes.
Okay.
As our previous visits, we weren't allowed to see the deck or inside the barn.
Well, you saw the deck from a distance, but you couldn't go up on it and, okay,
Yes.
right. And so what page are you looking at there on C4, the photos?
They start on page 16.
Okay. All right. So the deck, Mr. Hearing Examiner, is a fairly critical item here because it's a life safety problem. We've all heard of various disasters and injuries caused by unsafe decks collapsing and whatnot. And so, Mr. Thomas, if you look at 16, what are you showing us there with that photograph? Page 16 of Exhibit C4.
This is showing the joists that appear to be rotten and in disrepair, the decking that is rotten. You can see there's a post to beam connection there. It doesn't have any mechanical fasteners on it. It appears that the deck's been painted as an attempt to preserve the life of the deck, which doesn't seem very successful.
So it's rotted, no mechanical fasteners.
Yes.
The photograph, page 17. What's that showing us?
On page 17, you can show where repairs were attempted by adding a large number of posts to support the joist individually. This system's not approved by the residential code. There are posts sitting on cinder blocks. The posts are not connected to the cinder blocks in any way, and thus creates quite a safety concern where they could be removed and dislodged, causing the deck to fail, as that's the only thing holding the deck up. You can see where the posts meet the joists, there's no connection to tie them together, which causes a huge safety concern.
And is this just a single deck, or what's it look like?
It's very tall. This first story that we're looking at the bottom of, the floor level to grade underneath is 8 to 10 feet. It's very tall. And then above there's a second story deck, which is around 20 feet above grade.
So you have these posts supporting a 2-story deck that are not connected to the blocks.
True, or to the framing on the top of the post.
All right. So, and page 18, what does that show?
Page 18 shows the deck where it meets the house. It shows the ledger. So the ledger is the board that goes across the house that the joists are fastened to. You can see on there's no lag bolts as required to connect the ledger board to the rim of the house, which creates quite a safety concern. If you look on page C9, Exhibit C9, it shows what can happen if a deck is not properly attached to a house. It can fail, lives can be lost, and it's a huge safety hazard.
And C9 is an example that you pulled through your research on similar collapses?
Yes, it's a story about a deck that fell. It was during a children's birthday party when there was a large live load on the deck with residents on there at a gathering. The whole deck collapsed off the side of the building. It's about the same height as this deck, where it's a second-story deck. This one's even taller because it has a third story above it. If you look at the next page on C9, it also shows another couple of examples of what can happen if a deck's not, if the ledger board is not properly fastened to the side of a building.
Okay.
As well as the next page on C9. There's lots of examples in here. This is a huge safety concern. The residential code has changed drastically over the years to make decks safe because lots of lives have been lost.
And also, what kind of flashing do you generally need on that ledger board to prevent rot in accord with building safety standards?
There should be a flashing above the top ledger of the board that goes underneath the building paper and the siding, so as water runs down, it doesn't get behind the ledger board. There was no flashing I could see from this inspection. If water goes behind that ledger board, the connectors, which are already substandard, could be compromised, as well as the framing of the house in which the deck is connected to. If the framing inside the building is compromised, even if there are ledger bolts, that deck's going to fall off eventually.
Okay.
As you look on page 20, you can see the posts that are all sitting, page 20 of Exhibit C4.
Yeah.
You can see all those new posts. They're not connected to anything on the bottom, as well as the bottom of the posts are starting to rot already, as they don't look like they have been there very long yet. It doesn't appear from these pictures that these posts are pressure treated, in which case they should never even be used outside in the first place. Page 21 of Exhibit C4, you can see there's the joist connection where it meets the rim. You can see this specific joist here is totally rotten on the end. The structural integrity of it has definitely been compromised. You can see the last decking board, the furthest one away from the building, is not even sitting on anything, as the joist underneath it's totally rotten and decayed to nothing. You can also see where the post meets the beam. They've used a electrical nail plate that prevents drywall screws from hitting wires in a house. It's not intended to provide any sort of framing fastening in any way. It provides no substantial connection between the two framing members. Page 22 once again shows the substandard ledger connection of the house.
And it looks like 23, 24, 25, similar photographs showing deterioration.
Yeah, the whole framing system is definitely deteriorated. It looks like it's been painted in attempts to prolong the life, but as you can see, the paint's starting to flake off, and it's not providing any real protection from the wood, from decay, from the weather elements.
Then on 26, this gives you a view of the two-tiered deck system here and kind of the haphazard construction. Is that what you observed?
Yes.
Okay. Could you describe some of the other features of this kind of cobbled together structure?
You can see the posts from the posts that hold up the third-story deck that's over 20 feet above the ground are simply sitting on framing members that are not directly supported. Any structure should have a direct load path from coming all the way down to a foundation that's been properly connected, fastened with mechanical fasteners. There's no post base for the posts that hold up the second-story deck. The gaps in the handrail are way too big. An infant or child could fall through them at any time. You can also see the handrails are rotting, as well as all the framing members are they're decaying rapidly.
Okay.
Right, and there's quite a number of photos here. Mr. Thomas, I'm interested in, did you see any evidence that the deck is in use? Did you observe anybody on the deck?
I didn't observe anybody on the deck. There's doors from the house that open up onto the deck,
okay,
and they weren't barred off. There was nothing saying not to use them. They were totally unrestricted and looked like they were completely usable.
And so what's your opinion as a building inspector and code compliance officer? Is it safe for anyone to be on the deck at the present time? Can it bear some load, or is it unsafe for anyone to be on the deck?
My opinion, based off of the ledger connection and the state of the wood, is that no one should go on that deck. I think it's a concern of the dead load of the decking materials just sitting there by themselves. I view it as a hazard that it seems possible the thing could fall over in a windstorm. It wouldn't take much to knock it over, in my opinion.
And so I'm curious as to, in the notice of violation, you listed corrective actions, correct?
Yes.
And does it say that no one should go onto the deck? I didn't see that. Isn't the notice of correction action to secure a permit? Or what corrective action did you indicate was appropriate with reference to the deck? Isn't that on page 4 of your notice of violation? I'm not trying to trip you up. I'm just curious what you think would be appropriate corrective action.
It states that the city has issued a permit for the deck repairs and no work has been done on the deck. I talked to Owen Benson on the phone about this matter, and I recommended that the deck be removed entirely, as it's a safety concern.
Okay. So you have advised Mr. Benson to remove the deck. It's your opinion here today that no one should go on the deck.
I don't think anybody should stand under the deck based on the fact it could collapse at any time.
Okay.
I believe that also, Mr. Hearing Examiner, that this incorporates the provisions of the abatement of dangerous buildings code, and it also so I don't believe it's just simply you have to get a permit. Mm-hmm. I believe they have it's deemed a dangerous building. The
right,
deck
I was
is
just looking for the remedy that the city was looking for, and I think he articulated it, either removal or, well, I guess removal is your...
I would highly recommend removal. Even if someone was standing underneath it, it's a hazard to anybody in the area. If anybody some kids were to get on the property that weren't supposed to be there for any reason, it's a definite hazard.
Is it your opinion that it could be repaired, given its current condition that you just testified to in some detail?
In my personal opinion, I don't think it should be repaired. If they were to want a deck there, I believe it should be removed and rebuilt based off of the quality of the materials that I saw when I was out there. It didn't seem like any of that lumber was usable or had any substantial strength left to it to where it would meet the requirements of what lumber is supposed to withstand.
Okay, thank you. Are we ready then to look at,
Well, and again, that timing issue, we have the notices of correction that cite that as far as the violation goes. That's C5 dated December 16th, 2015, and also
and where is the corrective action? It's in C5.
the corrective action says you can do one of three things, and I'm looking at
It's on
page 6.
Page 6,
Yeah,
correct.
the building shall be repaired, the building shall be demolished, or the building, if it doesn't constitute immediate danger, may be vacated, secured, and maintained against entry. I mean, that, and in this case, you know, they can do one of those three things. They haven't done any one of those three things, of course, but
So where I said here,
you must replace the deck with structurally sound new lumber, and it must be constructed per the deck building tip sheet.
so that building tip sheet, like I spoke about, is the prescriptive requirements that they got with the over-the-counter permit for deck repair.
So when you stated in the correction notice C5, you must replace the deck, is that the same as removing the current deck?
That would meet the requirements also. But if they could remove the deck, and they have to make sure the doors onto where the deck was were inoperable.
Or they could repair it. They could repair it.
With
Well,
structurally
this is
sound
what I'm
lumber.
asking.
They'd have to rebuild it, but they could repair it, but they'd have to do it in accord with a building permit and get it inspected, right?
Yes.
Okay.
You directed my attention to page 6 of Exhibit C5, and the corrective action listed, it says the October correction notice required you to apply for a building permit to perform deck repairs. And then the next sentence says you must replace the deck. So I take it repair means replace. Is that what you meant by that, Mr. Thomas?
Yes.
Okay. And you testified that, in your opinion, people should be restricted from being on or under the deck.
Yes.
And that was in a conversation. You didn't
Yes.
put that in writing. Okay. Thank you. Do we still have the other alleged violations about the barn and the pool in
do.
front of us?
We do.
Yeah, so that same violation, as we're citing the same uniform code for the abatement of dangerous buildings, the next topic, it says, on December 16, 2015, the barn is an attractive nuisance and a dangerous building as defined under Section 2, 5, 12, and 13 of Section 302 of the Uniform Code for the Abatement of Dangerous Buildings. As of January...
I can read that paragraph.
Okay.
But what does that mean to you? Where's the
So what that means to me...
corrective action?
If you look at the same pictures from exhibit number C4, you can see the framing of the barn would be deemed a substandard, and under those requirements, under the Uniform Code for the Abatement of Dangerous Buildings, it would not withstand the load requirements for the barn to be usable.
And which photos are you looking at there, Mr. Thomas?
I guess you could start on picture number 2 of exhibit C4. You can see all the joists are all hung off of one 2x12. That 2x12 would be overloaded and would not be substantial to support the load for that floor space.
While we're looking at this same paragraph, I see there is a black pipe there. What is that? And this relates to the plumbing issue.
That is an ABS drain plumbing pipe.
Okay.
The next page, on page 4 of Exhibit C4, you can also see there's a water heater that is installed in the barn currently.
And did it appear to have an electrical lead to it also?
It did. There's a yellow wire running to it, which would
Okay,
be...
okay, but please, I need to make a lot of findings here.
Yeah,
Can we
sorry.
stick to what were we talking about?
we'll stick to
the
the-
barn?
We're talking about
Because we were
structural
wandering
integrity.
into plumbing and electrical. So the structural integrity of the barn is shown in photo C2, or C4, page 2.
Yes.
Also, I'd like to bring your attention to page 5 of Exhibit C4. You can see the 2x12 that the joists are hung off of is only held up by 2 nails going into the post. Once again, that's a substandard connection for the live load and the dead load that would be assumed on that connection when the barn is occupied.
I don't see what you're talking about. What 2 nails?
It's right. You can, it's right. The only reason I'm
In
pointing.
the center of the photo?
Yeah, right there. There's a nail there and a nail there. If I could,
Oh, I see what you're talking about.
So all those joists bear on that 2x12, and that 2x12 was only held up by 2 nails. So given the requirements out of Section 302, the Uniform Abatement of Dangerous Buildings, that would be classified as a dangerous building. Next, I'd like to bring your attention page 9 of Exhibit C4. It shows there's an unlocked open door on the back of the barn where there should be a deck or some sort of stairs to exit the building, and there's not.
Okay.
so what's the effect of that? Somebody could walk up there, not notice.
Someone could walk up there. When I arrived on site, the front door to the barn was unlocked, and that door was open. If it was night and some child or some teenager were to be walking around the premises and it was dark, they could absolutely walk out that door and be severely injured.
All right, so that's with reference to the barn.
Yes.
It has a violation in the NOV. And also, you testified as to the deck. The third item listed is the pool is unsecure and an attractive nuisance. Is that something that's before us today?
Yes.
And that, is it your testimony, or Mr. Litton, how do you want
Nope.
to?
If you look at page number, it's Exhibit C4, page 36. If you look in the back of the pool area where the handrail for the deck meets the chain link fence around the pool, you can see it looks like about a 1 to 2 foot gap between the two, leaving the pool unsecure and a definite hazard to anybody on site that might walk in there and fall in it, or any children that might be in the area. You can see the pool is full of water and a definite drowning hazard.
Your statement is there's a gap in the fencing, from the lattice fencing to the chain link?
Yes, sir.
Okay, thank you.
The next item on the notice of violations, item number 4, violation of a permit required. I would like to bring your attention to section C6. There was a previous hearing in April 2013, in which I believe you ordered them to remove the plumbing from the building.
Well, let's take a look at that. And we have different evidentiary standards as to relevance and other standards in a hearing examiner proceeding. We have the appellant here not represented by legal counsel. I'm hesitant to raise any objections to exhibits offered. However, I'm looking at this exhibit C6 and wondering how I could rely upon it when it's involving a Mr. Daub, who's not before us today, and a Mr. King, who's not present today. And it looks like the order was issued against a Mr. King and Mr. Daub. Is that why you're offering this Exhibit C6, Mr. Linton?
Well, yes. There was an outstanding abatement order that has never been complied with as to this property.
Well,
It's-
I guess we're
it's-
getting to the in personam or in rem, and here we have
Well,
Daub and King,
Yeah,
and we have Mr. Benson here for the appellant. Is it relevant to the notice of violation allegations as to Mr. Owen Benson?
Well, yeah, and that's the issue.
Yeah,
Mr. Benson was the owner at the time that this was issued. He
But he
wasn't.
wasn't
He
named.
wasn't a party.
Yeah. So maybe I should ask you this. How could I possibly rely on Exhibit 6, since it doesn't involve the same appellant? And I don't believe I have the jurisdiction to allege or to make a judgment against the property. It's the person named.
Well, the code actually says that the
Maybe we
it's
can
not
try.
a judgment. It's a determination.
It's an order
It's an order.
that wasn't taken to judgment, do you know?
It wasn't taken to judgment.
Okay.
The code says that it becomes a lien against the property itself. Now, that doesn't mean that we can necessarily collect on a lien, but it is.
Okay, and we're not at that point yet of offering it for any assessment of fines, but your witness mentioned at Exhibit 6, stating that there was a determination made in 2013 about the need for a permit. I think that's why he brought it in.
Well, it was actually an order, the finding or the order by the hearing examiner, which was you, was to remove electrical and plumbing from the premises of the barn.
Mm-hmm.
And
And what your witness was testifying to, it was the notice of violation number 4 on page 4 of C8.
correct.
And the statement he made was that a permit was required as long ago as April 9th, 2013. So if it's offered for that purpose, I guess we could have it in front of us. I just don't think it relates to Mr. Benson.
The property was in Mr. Benson's name at the time.
Right, but I didn't make a finding as to Mr. Benson's responsibility.
Well, and I can certainly see your point on that. Alternatively, it's a condition that had been noted in 2013, and I believe it's probative of the fact that this property has been lacking for an lacking in compliance for an extended period of time.
Okay,
So I
we
believe
can have it in
alternatively
for
it's
that
relevant
reason.
for that.
okay. All right, fine, let's do that. We'll have it as an exhibit showing that there's been problems on the property for a few years, but it doesn't go to Mr. Benson, who's the appellant here today.
Right. Now, that being said, the November 4th correction notice does refer to this, to the previous 2013 order, and lists a corrective action to allow access for inspection of the loft area above the barn. That's C3, page 6. Then on the next corrective action notice, once that inspection occurred, the the correction notice dated, which is C5, dated December 16th, says that corrective action, all plumbing fixtures in the barn must be removed per the findings and conclusions described above. So in essence, this is telling Mr. Benson and Mr. King in the correction notice, that is C5, to do what was already told, they were already told to do. So
Well, Mr. King was told to do, and now Mr. Benson, as of
now
the date of
Mr.
this
Benson is
correction.
being told to do.
Yeah,
Yeah.
okay.
So I believe that you could also find, you might find that, well, I can't assess $500 a day from 2013. I mean, we're asking that you do that, but you could say, well, I may not be able to do that, but I can assess from.
Well, let's get there when we get there. We'll get there when we get. We're not quite there yet.
Right.
But your witness brought this up with reference to an alleged violation about what plumbing permit required.
Right.
Okay, so that's where we are.
Yeah,
and failure to remove plumbing fixtures. So
Right.
these are the alleged violations 4 and 5 in C8.
Exactly. So that completes the violations that we've cited in our notice of violation, correct, Mr. Thomas?
Yes.
And were those plumbing fixtures removed?
The water heater would be classified as a plumbing fixture, and it was currently installed still.
Okay, and is there still water service to the barn?
Yes, at the time of my inspection, there was a hose bib on the back side of the barn that was still installed and leaking. It was.
What's the date of that, your inspection?
I believe this is from my 12-1 inspection. Let me pull the picture up real quick. Page number 12 on Exhibit C4 shows a hose bib on the back of the barn that was broken and leaking water at the time of my inspection.
Okay, so the water heater and this water bib.
Yes.
The plumbing fixtures. And were
And there's
there any
also-
that were removed that had been there earlier?
It looks like there's sinks and toilets above from the unit above the barn that had been removed. And while the fixtures have been removed, there was still drain lines in the barn that could easily be hooked back up again to put it back in service.
Thank you.
So would it be, in your opinion, that with relative ease, those fixtures could be reinstalled, they'd have running water and electricity available for habitation there?
Yes.
Okay. And if you take a look at page 7 of Exhibit C4, we get back to this soil pipe that's still there with what appears to be an electrical connection hung over it, right?
Yes, that is what that is.
Did you check and see whether there was any valid electrical inspection
I did.
of the barn?
There has been electrical inspection and there's electrical approval for the circuits ran to the barn and the meter that's on the barn. The wiring that's in the barn, as you can see, this gray conduit that has electrical wire in it and this yellow wire hanging over the waste pipe has not been approved by Washington State Labor and Industries having jurisdiction over electrical inspections.
So is it your observation that there are uninspected electrical installations at the barn?
Yes, it's also my observation that this type of installation will not be approved.
Okay. Is there anything else you'd like to testify concerning these various violations?
No.
That's all the city has.
Okay, thank you, Mr. Thompson. Stay there for a moment.
Excuse me, Mr. Hearing Examiner, it's Thomas.
Thomas.
Mr. Thomas.
Thomas,
Yeah.
thank you. So,
We've got a
Mr.
Thompson and we've got,
Yeah, we
Thompson.
want to keep those separate. Thank you. So, Mr. Thomas.
Yes.
About the permit, the permit was issued only for the deck, is that correct?
True.
And about the water heater, is that on the second floor or first floor?
First floor. By first floor, it's a barn, so there's no floor framing. It's just dirt underneath there. But yeah, it's the first floor.
I see. And the reason I asked that, in your notice of violation on pages 4 and 5, the statement that's made is that there was failure to remove plumbing fixtures, including toilets, sink, and showers, from the second story of the barn. And I think I heard your testimony is that the sinks and toilets were removed from the second story, but the water heater on the first story was not removed. Did I hear you correctly?
Correct.
So is it still your opinion that there was non-compliance with that?
Yes.
In what way?
It's a fixture in the barn. It's installed illegally. It wouldn't pass inspection if they were to get a permit for it. Also, they wouldn't be allowed to have any...
The water heater?
The water heater, yeah.
So, okay, that's independent from non-compliance with the order. You've determined that because there's a water heater there, that's a violation.
It's a violation, and also because there's a water heater there, it'd be very easy to put sinks and toilets back in the barn.
Okay, thank you. All right. Well, Mr. Benson, I want to give you an opportunity to present your case, and you can do that by direct testimony to me in response to what you heard from the city witness. Would be one way to proceed. Do you have an opinion or how you would like to respond to the city?
I do have a few things to say.
Okay. So I could take your testimony now.
Excuse me?
I'd be happy to take your testimony now.
Okay.
And before I do that, did you have any questions for Mr. Thomas?
No, actually,
Okay.
I pretty much understood everything he has said, and I do not agree with everything, but pretty much understood everything.
Yeah, and that you don't have to agree with everything, but thank you, Mr. Thomas, for your testimony. You can please be seated back next to your legal counsel. Mr. Linton, is it okay with you if Mr. Benson testifies from his current position?
Absolutely.
Okay.
First of all,
wherever you want to tell,
thank
you're bringing something forward to me.
Declarations that will be tried to put together over there. You want me to stand here?
Wherever you're most comfortable.
Okay, here.
You can
Because,
you can sit there. I see you have some materials in front of you.
Mr. Thompson.
Yes, and that's fine. So let me make a couple of things before we get started. First of all, I want to put you under oath. So when you're ready, I'll ask you raise your hand and take the oath. Do you swear to tell truth in testimony you give today?
I do.
Thank you. And now you handed me some materials here labeled Declaration of Owen Benson, of David Thomas, and a declaration of Roger Knight. Are these items you wanted submitted into the record?
Yes.
Did you have copies for the city?
Yeah, give me one moment. I know I got them here somewhere.
Okay, or we can get copies made if that would be helpful.
They're right in here somewhere in these papers.
Okay, and I can hand them to the city attorney so he can review them. One involves Mr. Benson's declaration on getting an attorney, and a continuance, and an appointment of an attorney. Declaration of David Thomas is on submittal of witness and request for an attorney. And then there's declaration of Roger Knight on the continuance.
You want to hand them, or?
Oh, if you can hand them across, and we give Mr. Litton an opportunity to review them and see whether he has any objection to them becoming part of the record.
No objection.
Okay, then we'll have these declarations as part of this record of this proceeding.
Okay, we covered a lot of things here. See if I can remember. First of all, the point of this hearing is to ask the hearing examiner for an extension of time to complete all the code violations that have been submitted, to correct all the code violations. And you had discussed that earlier, and it is my opinion that we haven't been given since December, since they were giving in last fall, adequate time to address these issues. We've had the wettest winter since 1896, and so weather and other personal issues have delayed our response to the code violations that have been presented mainly. Some of them I wasn't aware that such as issues with the barn. Try to take in. We got here. Let's see. It's right here. King assessment of ownership, hearing, C3 notice of violation supporting documents.
What document are you?
I'm just trying to. You went through all these things, and I'm off the top of my head. The vehicles. There's two vehicles that Mr. Thomas had mentioned: the truck and the car. The truck is a 1952 Ford dump truck. It is a true antique.
They both have collector.
And
Take one at a time.
yes, and both the vehicles have collector plates, and
What's the second one? So one is maybe a 1950s dump truck, would you call it?
Yeah, it's a.
Well, I need to
it's
take
in the
one.
50s.
$1952.
We've got to be careful here because it's being recorded.
I'm not sure the exact year of the truck, but it's an early 50s dump truck.
Okay, and do you know what the other one is?
It's a 66 Pontiac Le Mans.
66 Pontiac Le Mans. And it has a straight body, it has an engine, there's no broken glass.
Can it be started?
It can be made to
Mr.
run.
Thomas, really, or Thompson, really, I can only take one witness at a time. I'll give you a chance. I know you're trying to help him, but I think he's doing pretty well.
Okay.
All right.
Yes, we believe all the vehicles can run, will run with minor care.
Okay. And when you say they have a collector's license, is it a current license?
Yes, as of today, they're current licenses on both vehicles. But regardless of that, we are more than willing to comply with whatever the hearing examiner determines. In other words, they don't really have to be in the lot.
Okay. So that's your response to the city claiming you have 2 junk vehicles.
Yes.
And what you're saying is they're not junk vehicles, they're antique vehicles that are recognized by a special license.
Mm-hmm.
And although they're not operating now, you agree with the city they're not operating, you feel you could bring them into operation.
Correct.
Okay. Now, how does that relate then to the second notice of violation about how many vehicles are on the property?
He mentioned the tractor, and we weren't sure if that was in the vehicle count or not, but anyway, the tractor will be stored in the barn and out of sight. So I hope the tractor will be no longer an issue. The vehicle count will be under 8.
Do you agree that
once I haven't taken an exact count because we weren't sure. Some of the vehicles are registered elsewhere, we weren't sure if they were actually had needed to be included in the count or not. So
well, we heard the testimony of Mr. Thomas saying that any vehicle parked more than 8 he considers a violation. He said he has some discretion. If it's some people visiting, he may or may not consider it a violation. But do you agree that there are currently on the property more than 8 vehicles parked?
No. And we were counting the trailer as a vehicle, and when we were doing our counts, and then as his testimony, the trailer is not a vehicle, but we're attempting to deal with the trailer in a timely manner.
Mm-hmm. Did you count the junk vehicles? What they had claimed to be junk vehicles?
Yes.
Did you, Mr. Thomas, count those?
And the tractor. But regardless of that, we'll go over the vehicle count again and be sure that the vehicle count is under 8.
Mm-hmm. Okay. So those are the first 2 alleged violations. What about the next ones, about the deck, for example?
Okay. Again, the problem with the deck we've had is the rainy weather and our inavailability of our professional building people to get there and to make their assessment of what needs to be done. But we have blocked off the bottom of the deck. We've blocked off all the entrances to the deck, and are not allowing anyone on the deck that is not doing a repair. So we're listening to Mr. Thomas and following his recommendations as best as we can. So when we can get our professional consultants up there to tell us what it needs to be done to meet code, as he said, it is currently cobbled together, but we will make those corrections, and if necessary, we will remove the deck after we get those the communications from our consultants that have not been available because they are professionals and busy people too.
Okay, so when did you first get notice from the city that the deck was a problem?
When was that?
I think the city testified, and it's part of
I
these.
mean, he's given those testimonies. We're not arguing with any of the dates that.
Okay, so
Thomas
maybe
has
as far
given.
back as September of 2015, September of last year?
Yes.
Mm-hmm.
But we weren't aware of the nature of the problems, and we thought that we had been addressing them at that time.
Okay. And when you say you've blocked off people from going onto the deck, you've blocked it off? How have you blocked it off?
Well, we have pictures. We barricaded the two entrances from above, and then we put up a tarp beneath, and put furniture in front of the doors of the 3 inches to two above the door, the deck, and put the refrigerator and close the door to the underneath the deck. We believe that it's adequately blocked off.
Okay,
But we don't want to make it too difficult, so that we need to access the deck so we can assess the
Understood.
and get our workers in there. And
Understood. But you agree that it's dangerous now to allow someone to be on the deck except for review?
We're not contesting his opinion, no.
Okay.
But what we are contesting, we're asking the examiner for more time to repair the deck.
What is your plan for deck repair or replacement?
We don't have a plan yet. We haven't been able to get our consultants over there.
Well, then nothing gets done without a plan. Have you thought about what time frame you would need to do either removal or repair of the deck? You've testified that it's been too wet. If you first heard of the problem, you, Mr. Benson, in September, then you had last fall, too wet through the winter. Now we're coming into spring. We hope and it's too wet, meaning you can't make the repairs because of the moisture on the deck itself?
Well, construction in the rain is slow and difficult.
Okay.
Especially outside.
So as we're coming out of the rainy season, what is your...
We should be, within 2 weeks, we should have, be able to submit a realistic plan on doing bringing the deck up to code.
Okay. And you live on the property now, is that correct? So you're looking at the deck every day, or you could, and you're thinking about it. Mm-hmm. What amount of time would it take, do you think, to repair or replace the deck? Longer than 30 days, once you had your plans in place?
Again, it has to depend on what our consultants say and what it needs. According to Mr. Thomas, that the deck was not built properly to begin with. Mm-hmm. And we weren't aware that the ledger was not bolted to the house until this testimony. Maybe it was in the documents.
I see.
But, so
his testimony today gave you information about what is needed.
We weren't aware of that, and I didn't look underneath the portion of the decks, and Mr. Embright, the previous owner, didn't put the proper footings supporting the posts, and so the repair to the deck is more extensive than previously thought.
Yes, I heard that too from the testimony today. Did you also hear Mr. Thomas say that it's probably best to remove the present deck and start again?
Yes.
What do you think of that idea?
Cost is an obstacle.
Mm-hmm. You could save any material that's still good material, but when I heard his testimony about the supports not being treated material, and that there's
just some temporary supports on the deck for
and
now.
maybe some rot on the ledger board, it may be best to remove and then salvage the material you can use again.
Correct.
Yeah, and that's the opinion you want to get from a contractor?
From our consultants, we have them lined up, and
You have someone that does deck building or repair?
yes, we do.
Okay. Do you know who that is? Can you think?
Individuals that are experienced
Or contractors?
experienced
Are they-
contractors, construction workers, and they're very good, and they're employed.
Is that a company, or you can think of their names, or who would that be?
It's through Paul King.
Okay.
So they're acquaintances of him.
Okay. Have you made appointments with them to assess the repair or removal and replacement?
I'm not sure of the dates, but I believe I know that he has contacted and he is attempting to make
Okay.
appointments.
How is Mr. King, how is he involved with the property? Is he part owner of the property? Does he have an ownership interest in the property?
Yes, he was the attorney that was involved in the acquisition of the property from Mr. Enright.
Okay. Didn't Mr. King deed the property to you 10 or 12 years ago?
Yes.
Okay, so do you consider yourself the owner of the property?
Yes, I am the owner.
Anyone else have an ownership interest, or do you consider it your property?
It's my property.
Okay. So does Mr. King live on the property?
Yes, he does.
Mr. King lives on the property.
Yes.
Okay. Does he also live in Bremerton? That's the address that he's given in his declarations.
I can't speak to that.
Not that you're aware of. Okay. All right, so that's relation to the deck. You also heard testimony about the pool and the fence, the gap in the fence. Are you aware of that?
Yes. According to my discussion with Mr. Thomas, we have partitioned off the pool. We have put chain around both gates, and no one is no one has easy access to the pool area, and we are hoping that when we do the deck repair, we'll also make the gate all the way across.
Is there still that gap there between the wood and the chain?
There's steps between the deck and the pool.
Okay.
But we probably will
Right.
be making.
And I'm looking at the photo that Mr. Thomas referenced. It showed a gap, the gap between the wood and the chain link. Has
Yes.
that been closed
Yeah, we're
up?
going to completely enclose the pool,
Okay.
or fence the pool, I should say.
All right.
That's our intentions.
Okay. And I think the other violations the city testified to had to do with the barn. What's the status of that?
Well, according to my conversation with Mr. Thomas, is that we need to block the entrances off to the barn and remove the hose bib and remove the pipe from the water supply to the barn. And this was the first. He didn't mention the hot water tank, which or the drain or the electrical in the barn. These were new to me in today's testimony. So I think we've already we saw the pictures, and we cut that one drain pipe that was missed previously. We felt that it was a 2013 hearing. We felt that all the issues that had been already addressed at that, and bringing these new issues up is new to us.
Okay.
We weren't aware of the structural problems with the barn. So at this point, what we were just hoping to close the barn off and defer it to a later date where we're more able to deal with it. Right now, we have enough to deal with the deck.
Okay. So how is the barn used by you currently?
Not used.
So
Well, it'll be used to store the tractor and maybe some other items.
So when you
Some of
say
that
you
plastic
would,
pipe that's unsightly on the properties,
okay,
stuff like
when
that.
you say you would close off the barn, we saw one exit that didn't have steps. You mean you would block that exit, for example?
The loft will be closed off as well as both entrance to the barn. Mr. Thomas told me that he was not concerned about blocking off the barn so that nobody could see it, that just the entrances, and the only entrances and the blocking off only needed to be 4 feet tall.
Okay, so you agree that it's not suitable for someone to live in the barn. I think in 2013 it looked like maybe that was the
We've
direction.
understood that it wasn't suitable to live in the barn since 2013.
Okay, so the water heater is it being used currently, or it's
No, I personally disconnected the electrical, the water heater, and I don't believe there's any plumbing from the water heater up to any fixture. So the water heater is just stored in the barn. And if it is a concern to the court, we will remove the hot water heater.
Okay. All right. Well, thank you for your testimony. Is there anything more you wanted to add?
Does that? I could speak to Mr. Sigworth, if that's a.
No, I don't think the city brought anything up about.
Why he is complaining, what the nature of his complaints is.
Oh, I see. He's your neighbor? Is that?
He is the previous owner of the neighbor's property.
I see.
He has, feel like he has or should say had an vindication against us because because of a failed sale.
Okay. Yes. Is he no longer your neighbor?
No, correct. He has sold the property
Okay.
to another.
And have you met the current owner of that property?
We don't believe we have an issue with them.
I see. They haven't complained to you directly.
No, they haven't talked. But if they do have an issue with it, they're welcome to talk to us.
Okay. Very good.
And again, as I previously stated, that going through Mr. Thompson's testimony, you have noted that there has been substantial cleanup and an improvement on the property, and there will continue to be to not only to make the property more presentable for the city, but a nicer place for us to live.
Okay. And we say for us to live, that's you, and who else is living on the property?
There's me, Mr. King, part-time, and there's an individual named Kevin Fallon.
Mm-hmm. Okay. Well, thank you for being here and for your testimony. And Mr. Thompson, is he someone you wanted also to testify?
Well, he's here to because he is our mechanic and our main handyman,
Okay.
and he has and he needs to have detailed knowledge of all that is going on with the property, so that so he can address those issues.
Okay, good. I'm glad he's here. I think it might be appropriate to find out what the city's asking for, because this is a hearing.
Well, we learned that on this meeting again.
And they're asking for certain corrections, but to determine if they're also seeking any penalties at this point. because we have two ways to go. I have authority under the Kenmore Municipal Code, the ordinances, to direct that certain actions take place by a certain date. That's what I did in 2013, not for you, Mr. Benson, but for Mr. Daub. Is Mr. Daub no longer involved in the property?
Correct.
Okay.
Mr. Dodd has moved on.
Okay. So we either direct specific activities or establish any monetary penalty or both. And so I'd like to turn back to the city and see what their position is after hearing now your testimony as to what your plans are for the property, to see what the city would be asking me to do. Mr. Linton, are you prepared to do that?
Yeah, I am, but I would like to ask Mr. Benson just a couple of questions.
I think that's
Before-
okay. Is that okay
before
with
I
you,
get to
Mr.
that.
Benson?
Of course.
Certainly.
So, Mr. Benson, you testified that Mr. King, I believe the first statement was that Mr. King lives there, but then you said he lives there part-time. Is that correct?
Well, he's not there every night, and when he's not there, I'm not sure where he's at.
Okay, but he does live there part-time.
Yes.
And you purchased the property in 2003?
Correct.
And how much did you pay for the property?
The property was titled over, deeded over to me.
Okay, so you didn't actually pay anything for the property?
Correct.
And that was titled over to you by Mr. King, is that right?
Correct.
And do you have an agreement with Mr. King that if the property is ever sold, that he would receive some of the proceeds?
No, I don't have any such agreement.
No such agreement?
There's no verbal or written agreement on that.
What are we trying to get to here? I think
Just
your
ask-
Exhibit
just ask
C1
Mr.
establishes all of
King's-
that.
Just to see if Mr. King has maybe an informal interest in the property,
I see.
and whether, so does Mr. King help maintain the property?
Yes, he does.
Okay. And you help maintain the property?
Yes, I do.
Okay, so you kind of have a partnership together?
Yes, you can say
Okay.
that.
Now, does Mr. Fowler, is he part of that partnership?
No,
Okay. And
Fallon, I think, is
Pa-
Fallum.
I'm sorry, what was the spelling on that again?
Fallum, Kevin
Oh,
Fallon.
okay. Thank you. But you do live at the property full-time?
Yes,
Okay.
residence.
It's your residence? Okay. So that's all I got.
Okay. So let's move to what the city might be asking me to do in terms of any order or decision issued following this hearing.
Well, I believe it's been admitted that all of these conditions exist. I mean, I haven't heard any testimony that says that any of the citations or corrections requested by the city aren't justified.
Okay.
And in that regard, the violations have been established. They've been established as of September of last year. The code is pretty clear that in that case, penalties do apply. And so the city is asking for penalties. And with all due respect to Mr. Benson, I realize that he has this admitted partnership with Mr. King, and that maybe Mr. King hasn't done as much as he might. I don't know why these, the city doesn't know why these things haven't been corrected, why we have junk cars. They're admittedly junk cars. And actually the definition of junk vehicles, even if they can be started, doesn't mean that they aren't junk vehicles.
Well, the testimony I heard was that, yes, they could be operable, which means they're not operable now,
Yeah.
but also that there's a license on each one of those.
But-
So if you look at the definition of junk vehicle, where is it that they're still qualify as that?
Am I allowed to offer additional testimony in that regard to
Yes,
clarify?
that's what I
Okay,
meant to
sure.
do, and I
Yeah.
may have brushed past that, but yes, you have an opportunity to respond to the presentation of Mr. Benson, and then we'll get to that issue of penalties.
Great. Mr. Thomas, was there any thing you'd like to add in relation to the existence of licensing or not existence of licensing as to the vehicles, the junk vehicles?
The licensing is one of the 3 qualifications to be a junk vehicle. It needs to meet a minimum of 3 out of the 5 qualifications to be a junk vehicle. It's only 1.
What are the other qualifications?
If it's three or more years old,
What are you referencing?
KMC 8.25020.
020.
Yes.
And in your notice of violation, you cite to 010, definition of junk vehicle. Why is that not relevant? Do you have that in front of you, 010?
I read the notice of violation here, it says 020.
The notice of violation? On page 2, oh, you know what, it has both. Page 2, violation of 825.020, and then right below that, 825.010 defines a junk vehicle as follows. Which one are we relying upon? It seems to me it'd be the definition of a junk vehicle. Maybe that's just misidentified. Is it 020 or 010?
010 is the definition.
Okay, so maybe that bold reference to 020 should have been 010.
It must be a typo, yeah.
All right, and that's what you were telling me.
020, the violation, junk vehicle is defined under 010, the violation is 020.
Okay, and your testimony was to as 010, even though you said 020. 3 or more of the following requirements, and what were you about to testify to as those 3?
For one of the specific cars?
Yes. Why does it qualify as a junk vehicle? You heard Mr. Benson's testimony. He doesn't believe they are. They have a license. They have some value.
Okay, so the car in the lower area is 3 years or older. More than 3 years old, there's qualification A. It's apparently inoperable, qualification C, which means it can be operable, but if it looks like it's inoperable from my inspection, that qualifies as that. The other thing is, it is without valid driver's license plate or tabs.
Well, the testimony of Mr. Benson was that there would be a valid license plate or tab. Did you look for that when you were on the property?
I have to look on the pictures. I don't believe it had a valid license plate from what I saw.
I didn't see the photos indicated that one way or the other. Did you make an assessment? The other criteria is fair market value. Were you able to make an assessment of fair market value? Whether it has a value other than scrap?
I did not.
Because this issue has been put before us by Mr. Benson's testimony, where he stated there's a license plate, and I believe also that there are no broken windows or windshields or missing tires. Did you view any broken windows or windshields?
Are we looking at?
On there. This is the picture I took yesterday.
I think the best picture is Exhibit C4, page 44. We're talking about the Pontiac, right?
Yeah.
Yeah, all right.
And what does that show?
Well, you can see the license plate. It's not a collector's plate, for one thing.
The one on it in that picture is not. We have one to go on it as soon as we get back today.
Well, we haven't seen that, and we don't. I mean, I
Okay.
understand that's the testimony, but at the time that this citation was made, there's no valid license plate on it.
So is that, there's a license plate, but it's out of
Hmm.
date? Is that why?
Yeah.
Okay. Well, hold on. I want to let him finish, and then we'll see if there's any need for rebuttal.
And you can see
Okay.
also that it's all rusted.
And is this true with the truck as well?
Yes, the truck does have expired tabs. It is incurably inoperable and more than 3 years old, so it would meet those 3 qualifications.
Okay. All right. Is there other testimony you wanted to offer in response to Mr. Benson's testimony?
I don't think it's really necessary. I mean, they've admitted all of the only thing they really contested was the junk vehicles, as far as I could tell. They've talked about, well, they disagree with the number of vehicles. I mean, when was the last time, I'll offer some testimony on that. When was the last time you were out there, Mr. Thomas?
I was out there yesterday to take a couple pictures of the barn and some pictures of the lower parking area to verify the junk vehicle is still down there.
Okay.
That's from yesterday.
Okay. So junk vehicles are still there. What about the number of vehicles?
I didn't verify the number of vehicles when I was there yesterday.
Okay. When was the last time you verified the number of vehicles? Oh.
January 8th.
So on January 8th, there were still more than 8 vehicles there?
Yes.
Okay.
And did you look at the deck and barn areas as well?
I wasn't allowed access to go on the backside there. I could see from a distance that the deck had remained unmodified and that the questionably structurally sound lumber was still in place of where it was during my last inspection, and no additional fasteners had been applied to the deck.
Could you observe the pool area?
On my last visit, yeah, so that would have been,
Well, I thought you said it was January 8th.
yeah, I'm trying to find a picture that shows that. Yeah, you can see C7, sorry, C7, page 2 shows the pool area. So I went to go verify that the violations had not been corrected.
And they hadn't?
It had not been corrected, no.
Okay.
So we understand that there's a request for more time, and there's at least the notion that experts will be consulted. Mr. King will find some contractor, contact somebody, but it's all too indefinite, and at any time, this structure could collapse.
Okay, so what is the city requesting then?
We're requesting that all of these, that an order be given, that all of these conditions be corrected as stated in the notice of violation, and that penalties be assessed for the fact that we've been dealing with this for now over 6 months.
And what penalties are you requesting?
We're asking for $500 a day. $500 a day from the correction notices.
And what date are you using to compute that,
Well,
and have you computed
we've-
that?
11/4/15 is the initial correction notice. And the computations of the amounts we're requesting are included in the NOV on page 5. I would note that the $1,436,350 is actually a typo. It should be $881,350.
So $500 per day from November 4th, 2015.
Well, now, that's for all of the violations except for the plumbing fixtures. And on the plumbing fixtures, we are asking, as testified by Mr. Benson, He has an informal partnership with Mr. King, who also lives there. They're joint tenants. That indicates to me that Mr. Benson is bound by his partner's finding from
Where does that,
April 9th, 2013.
where is that, as a person responsible for the violation?
That's correct.
Is that within the definition
General partnership.
of the chapter 1.20?
No, it's a common law partnership.
So not as defined by the ordinance, but you want me to take cognizance of common law?
Well, it's actually under RCW 25.15, the Uniform Partnership Act, but yes. General partners are responsible for all acts of their common law general partner. So he is bound by that 2013 determination. That's our position.
That's your position?
Alternatively,
Uh-huh.
that those penalties could also be computed on the plumbing violations from November 4th, 2015.
And this is on page 5 of your Exhibit C8,
Yes,
where presumably Mr. Thomas has done those calculations.
that's correct.
And with reference to plumbing fixtures, you're seeking $508,500. Is that correct?
That's correct.
And then you
Plus the administration fee under the
and you have a 15% administration fee of $187,350. What's the basis for the? Oh, I see. It's in your ordinance.
It's in the
Penalties are
ordinance.
subject to an administration fee, but you're seeking a total of $1,436,000.
Actually, like I said, that's a typo. It should be $881,350.
Are you seeking default orders against Mr. King or Mr. Thompson?
We reserve the right to do that, but we're not seeking that today. And I believe it was stated earlier in our discussions about the request for a separate hearing, we believe they are in default and that they're liable for whatever is assessed against Mr. Benson. But
Well, the
they would have a
reason-
right to appeal that if we did, like the hearing examiner said.
The reason I'm asking is that you're seeking this total of $881,350 against Mr. Benson only.
At this hearing, yes.
Can you share with me how that would gain compliance? Is that ultimately the interest of the city, is to gain compliance with the code?
It's also a deterrent. There's a deterrence factor here. Someone who has actually failed to comply for over 3 years.
I don't follow that logic because Mr. Benson is here for the first time.
Well,
He was not named in that order.
except his partner was here 3 years ago.
Do you want to go that path and establish a date of partnership?
He's admitted to it, that they have a partnership concerning, and he's admitted that he was given this property without any consideration. That sounds like a joint venture partnership to me. And I believe that you can have a common law partnership and subject the partners to common liability.
Well, that's kind of a new wrinkle in this whole presentation.
We didn't have that
case.
testimony
So I need to ask
before.
Mr. Benson, do you understand the city attorney is making an argument that you have a partnership with Mr. Paul King? Is that your understanding of your relationship with Mr. Paul King?
I find his testimony
He's making an argument.
is,
He's not
is
testifying.
absurd, actually.
Well, I want to give you an opportunity to clarify your testimony.
First of all, it was my understanding that we had been in complete compliance with the plumbing violations of the barn. That there was no need for any need for any additional work to be done on the barn, that we had complied. I had talked to the previous code violation individual, Mr. Bono, what's his name?
Yeah,
And he didn't mention any code violations, and I had no expectations that there was any plumbing or electrical violations in the barn whatsoever. This is all, everything about the barn is all new to me. So going back 3 years, saying that we had.
Well, listen, I'm not getting into that. I've already made the statement that you were not part of that proceeding in 2013. So the only reason I'm asking you about it is that the city's position is you were in partnership with Mr. Paul King, and that's what I wanted to ask you about. Is it your understanding or belief that you have a partnership with Mr. King?
No.
Do you have a written document that's a partnership agreement?
There's no document. There's no verbal partnership as far as I know. This is all conjecture as far as I'm concerned on his part.
Perhaps I misunderstood his testimony.
Well, that's why I'm giving him a chance to clarify. Did you want to ask questions about partnership?
Well,
Because what you ask is that if the property was gifted to him or if there was understandings.
Well, I did ask him 2 questions about whether there was a partnership, and he stated that there was a partnership. So if...
Well, there can be a difference between a common understanding and a legal definition.
And I recognize that.
Okay.
It's one of those things that I believe the hearing examiner has discretion to determine.
I'll make a determination on that. I'm still perplexed, though, at the $881,000, how that would be of benefit to the city. I think part of my role here is to make certain that there is compliance, of course, with the law. A penalty is one way of gaining compliance. Perhaps, but in this instance, we have declarations from Mr. Benson about low income. He came here today asking for the assistance of an attorney. I'm a little hesitant to apply such extensive penalties. I think it's unprecedented in this city. It's never been requested before. So I'm really hesitant. I want to give you one more chance to think about what you would believe would be appropriate to gain compliance. Is this going to remain the position of the city?
Well, Mr. Hearing Examiner, we have to ask what the code dictates, and I believe that part of your discretion is to look at the circumstances and determine an appropriate penalty within the bounds of the code. As city staff, we don't have the luxury of making that determination. I mean, Mr. Thomas has observed a number of violations. We've seen a great deal of non-compliance, and we have a property that is clearly in a state of disrepair and likely a fire hazard, collapse, and safety violations. A number of people that are living there without any ownership. We don't know. There's no relationship. I mean, I would ask Mr. Benson, do you collect any rent from any of these people that live there? They're just friends?
You're talking about
Yeah, Mr.
Kevin Fowler.
Yeah. I take it you don't collect any rent from Mr. King, is that correct?
No, they're not collecting rent from Mr. King.
Or from Mr. Fallon?
I personally do not collect any rent from Mr. Fallon.
Does he pay rent to Mr. King?
He has an agreement.
He has an agreement with Mr. King?
Okay, we don't need to go this path.
Well,
any
it's
further.
just that you have a number of people sort of flowing in and out of this property.
There's problems on the property. I think we
Absolutely.
recognize that. Even Mr. Benson has recognized there's
I
some
would
differences that
I'd
need
like
to be
to
made.
say that Mr. Fallon is a disabled individual, and we are doing him a great service by allowing his tenancy there.
Yeah, but in your testimony, you admitted that the deck is in serious need of being needs repair. It's dangerous, and similar with the barn, which is why you're going to keep people out of there.
Well, we are going to aggressively pursue the repair of the deck. Not so much on the barn because the deck is an expensive adventure by itself.
Okay, understood. So I'm going to wrap up the hearing then, if we can do that. Because I've heard testimony from the city, you heard that as well, Mr. Benson, the nature of the violations. Some are of lesser concern as far as public safety, junk vehicles and excess of vehicles on the property might disturb a neighbor, but they don't cause harm to individuals. The notice of violation as to the deck and the barn, especially the deck, and I think you recognize this in your testimony, those are serious concerns. So I appreciate the steps you've taken to keep people off the deck. It would be so bad for you to have somebody be injured by the deck collapsing or someone falling through the deck. So that's a very wise step to take. As to the remedies that need to be given here in this matter, I need to think about those a bit because the city's asking for quite an extreme amount of fines, and my interest, I think the interest of the city, is to gain compliance. So I'm going to have to consider how best to do that. It is the code of the city that governs what I do, this chapter 120, and that's something I hope you're familiar with, that you're able to see that on a computer or get a copy today, or you can take a copy here, because that expresses what needs to happen following this hearing. And it tells me I have 10 days to issue findings and conclusions and to make a determination if a penalty shall be issued. So that's what I'm going to do. And then you would get a copy of that mailed to you. Is mail still the best way to get things to you? Is there any other way to get things to you?
Generally, the mail's checked every day. Sometimes we skip a day.
Okay. Because I know that's been a problem with my office, is to get things to you quickly, because there's been a lot of motions filed, but we've been mailing things to you, and sometimes that can be a 2-day delay. But this will be mailed to you then, my decision. Thank you for being here with a respectful attitude and giving your testimony. And thank you, Mr. City Attorney, for trying to guide us through what's become kind of a morass in a way, because we've got this older decision in front of us. I think we all know the property's been an issue for some time. This is the first day we've heard from Mr. Benson, and this is his appeal hearing. Not making any determinations with reference to Mr. King or Mr. Thompson. I know Mr. Thompson had to leave the room, but I'm not making any determination against him or for him. Okay.
It's a bit of a temper.
Yeah. But I will conclude the hearing today, and I will issue the decision in a way that I hope you understand it. I'll be careful to write it in a way that's understandable. If anyone disagrees with it, there is an appeal opportunity to appeal my decision. So thank you all for your time and participation in the hearing today. We are now adjourned.